So the issue of a state's outright concealed carry ban was recently struck down, but it's once again up for review on the merits after the Supreme Court's recent denial of an emergency review. So let's break down what is happening in this critical challenge. Now, real quick, if you're watching this channel, then obviously it's safe to say that you care about the Second Amendment and your rights. Now, here's the thing, even law-abiding gun owners are ending up in jail because they make a bunch of critical mistakes. And those are mistakes that you don't even realize that you're making or that you don't understand that they're illegal. So I put together a free resource called the Legal Survival Guide. It's aimed to help you guys avoid all of those traps that maybe you could fall in. It takes about 2 minutes to read. It's just a simple PDF, and it really could save you years behind bars. I made it to help you guys, again, completely free to download using the link down below. It's just something that I wanted to provide you guys for free so that you can have it in your phone or maybe print it out. And there's a little card also in there that you can put in your wallet to give you additional resources to help you in situations. Obviously, not meant to be legal advice. I'm not your attorney. This isn't an attorney-client relationship, but I wanted to provide you guys some free resources to prevent you falling in some bad situations. Again, if you're interested, click the links down below. It's completely free to do. All you have to do is enter your email to get that free PDF. Now, as I mentioned in the intro, in this video, we're going to be discussing how this issue of concealed carry bans in the state of New York has once again been ruled unconstitutional, but the Second Circuit just heard oral arguments on the merits of this challenge. You may recall that recently the Supreme Court issued an 8-1 decision in the Rahimi case, and then after that remanded all of the New York concealed carry ban cases back down to the lower courts for new decisions in light of what they just said. There are two primary challenges in the state of New York and in the federal courts there challenging the New York CCIA law, and that is the Antonyuk case. However, that was sent back down to the district court for a final merits decision. But while all of that was happening, there was actually another case, the Christian case, which there was a summary judgment decision issued by the lower court there, and now this case is on the final merits and it's in front of the Second Circuit. The district court in the Christian case actually struck down a major aspect of the CCIA law, which was in direct defiance to what the Supreme Court said in Bruen, and that was the catch-all property ban that the state of New York put in place and that we've seen other states put in place like California, Hawaii, and others. However, after the district court issued that new decision striking down that aspect of the New York carry ban, the Attorney General there, Letitia James, appealed up to the Second Circuit, and now the Second Circuit has held oral arguments on this critical challenge. In my impressions after listening to the oral arguments is that the Second Circuit will actually likely agree that the catch-all property ban in the state of New York is still unconstitutional. Now, this issue of concealed carry bans in laws really should have ended after Bruen. This whole issue in New York really should have been resolved after Bruen, but in direct response to Bruen, New York passed a new law, which was even worse than the one that existed prior to that ruling. That new law was challenged in multiple cases, and some preliminary injunctions were sought and eventually granted, which halted some aspects of the CCIA. Now, since that, multiple cases like the Antonyuk case and others have attempted to get the Supreme Court to step in on an early basis, on an emergency basis, but the Supreme Court has kind of stayed true to their track record, and what they've categorically done is deny emergency review in all of those cases. Now, while all of these other cases were seeking emergency review, there was another case which we're talking about in this specific video, which is the Christian case, that was sent for review in the district court on the final merits, and ultimately the court there reviewed a summary judgment motion and granted it in favor of the pro 2A side here. And there you had Judge Sinatra that actually issued a favorable pro 2A decision. In that decision, Judge Sinatra stated that a newly enacted New York law makes it a felony for a concealed carry license holder to possess a firearm on all private property unless the relevant property holders actually permit such possession with a signed or express consent. At least as to private property open to the public, New York's law's restriction is unconstitutional as a result dictated by the teaching of the Supreme Court's recent cases addressing individual Americans' rights to keep and bear arms. Now, in that decision, the court relied on the Second Circuit's prior decision in Antonyuk, which also rejected the catch-all property ban and these public property bans. Judge Sinatra in that decision stated that, as the Second Circuit observed in Antonyuk, no matter how expansively we analogize, we do not see how a tradition of prohibiting illegal hunting on private lands supports prohibiting the lawful carriage of firearms for self-defense on private property that is open to the public. So here you have Judge Sinatra, which rejected the state of New York's justifications for this catch-all property ban. But once again, the Attorney General, Letitia James, has appealed to the Second Circuit. She wants a reversal of that ruling, and that appeal on the merits was just argued in front of the Second Circuit. Now, during those arguments, the state of New York argued for the catch-all property injunction issued by Judge Sinatra, that it should be reversed. However, while listening to the arguments, it appears that at least 2 of the judges on the 3-judge panel actually are in favor of finding that that catch-all property ban is still unconstitutional. One judge was concerned that the catch-all ban is too broad and does not actually distinguish between the types of property that the state is trying to regulate. Another judge during the arguments asked, how does this law not actually categorically burden the right to carry? He even mentioned Judge Van Dyke's Wolford dissent in the Ninth Circuit. And there you had Judge Van Dyke in a dissent. He brought up concerns on how these laws in essence operate to where you could only lawfully carry on streets and sidewalks. And so Judge Van Dyke had issues with how these laws are applied in the Ninth Circuit. And so here you also have a judge in the Second Circuit that shares that same sentiment. Then there were a lot of arguments on the historical justifications that the state of New York is trying to use to justify this carry ban. The state relies heavily on some hunting laws and older laws that were focused on restricting access to plantations and essentially carry bans also for African Americans. The use of these kind of old discriminatory laws is nothing new. We've seen California rely on these heavily, and now New York is also trying to rely on them heavily. But you had the judges here on the panel say, well, that's ridiculous. You cannot use those types of justifications to uphold this carry ban. They do not align with what you're doing here in the state of New York. You should not use these old discriminatory laws as justifications. And also, these hunting laws that you're trying to use do not justify a catch-all carry ban that you're trying to put in place. Then there was some discussion and arguments about how we would never treat the First Amendment right this type of way, where a property owner would have to give you express consent before you would actually exercise free speech on property. And so there was a discussion about how the First Amendment is treated different and how the Second Amendment, of course, is treated like a second-class right. And finally, there were questions of if the preliminary injunction issued by the prior Second Circuit in the Antonyuk case, if that's binding precedent. And there was, discussion about how should they look at Antonyuk because it was a preliminary injunction decision, but also they still found that the catch-all property ban was unconstitutional. And here, of course, you have the pro-2A side say, you found it was unconstitutional on preliminary injunctions. You should find the same way here. Judge Sinatra found the same way also down below on the merits. And you can look at more history, more tradition that was developed at the lower court level, but still that would say that this type of catch-all property ban is unconstitutional. So in general, listening to the arguments, I think it went well for the pro-2A side. I think there's at least 2 judges that are going to agree with Judge Sinatra and find that the catch-all property bans are still unconstitutional. I think there may be some portions of the CCIA that they uphold, but since this case is on the final merits, it would kind of prime this case perfectly to go to the Supreme Court finally on the merits and ask for the Supreme Court to step in and deal with these carry bans that were put in place in direct defiance to Bruen. Currently, the Wolford case out of the Ninth Circuit is seeking Supreme Court emergency review, but still that's on an interlocutory posture. It deals with a preliminary injunction. But the one good thing for that case is you had the Trump DOJ step up, and they're arguing that the Supreme Court should still take review of the case and strike down these laws that were passed in direct defiance to Bruen. So that's one of the things that could develop here that would also impact this Christian case in the Second Circuit. If the Supreme Court decided to finally step in on an emergency basis because the DOJ is prompting them to, that could change a lot of things with these carry bans. However, again, categorically, the Supreme Court has denied all of these interlocutory cases dealing with carry bans. So this is a case we're going to be watching closely, and I'm interested to see, how the Second Circuit rules on this issue. But generally, I think the arguments went well for the pro-2A side. So that's what's currently going on in the New York concealed carry ban case that was just argued from the Second Circuit. This is one of the big ones. It's one of the ones that's furthest along procedurally. It's on the final merits, and it's probably going to be the big case that makes its way to the Supreme Court on the final merits, unless the Supreme Court decides to step in early in the Wolford case. So as we get more information, as this develops, I will let you guys know. If you like this video and you like to support the channel, one of the best ways to do that is simply to like, comment, and subscribe. You can also check out my website, armorscholar.com, where we have a free legal guide that you can sign up for. All you have to do is put in your email to get that PDF. We also have channel merch over there and some daily deals where you can check out, some of those deals and save some money. But as always, thank you guys for watching. Don't forget to like, comment, and subscribe. And never forget, this nation was built by Armed Scholars, and this nation will be maintained by Armed Scholars.